Pitfalls. We had toyed with the idea of calling it the ABC of PRS and RTB, but I wasn't, with any degree of confidence, sure I'd be able to articulate it on the webinar this afternoon. My name is Jamie Fitzmaurice. I'm a partner in Mason Hayes & Kearns Real Estate Department, and I'm joined this afternoon by our two resident experts, Colm Farrell and Laura Farrell. Laura is a senior associate in our real estate department, but before joining Mason Hayes & Kearns, she spent 12 years practicing as a barrister. She has written the 2019 authoritative book on residential tenancies, aptly titled Residential Tenancies, which won the Irish Law Book of the Year award at the Irish Law Awards 2019. And we won't ask Laura to confirm, but apparently Lenny Abrahamson is in discussions with her about creating a mini-series for RTE and BBC. Colm is a senior associate in our commercial litigation department, and Colm specialises in landlord and tenant law, both on the commercial side and the residential side. He has appeared before the RTB, not personally, but he has appeared on behalf of clients several occasions, both at the tribunal stage and at the adjudication stages for a variety of clients, institutional tenants and receivers. So the tenure and thrust of the overall conversation today is very much going to be focused on residential tenancies. But what we've all come to realize over the last number of years is that when you scale up those residential tenancies into what has become known as PRS or BTR or multifamily, irrespective of what you're calling it, it becomes very, very important to know what you can do, what you should do, what you can't do, and what goes wrong if you're caught out. This is particularly the case for institutional landlords or large landlords where they have multiple tenants, because getting things wrong can be a waste of your time, can be a waste of your money, and can also result in reputational risk. So ahead of the webinar this afternoon, which incidentally is being live streamed on YouTube, we were just told before we went live here this afternoon, we did ask you when registering to submit any questions that you might have to allow us, I suppose, really answer the questions that you want to know. And thankfully, we got a large response to that. And what we've tried to do is to collate all of those questions into a series of buckets and come up with some kind of generic questions. And you'll see what those topics are on the slide there in front of you. But to keep things interesting, or at least interesting from our perspective, what we're also planning to do is to run three quick surveys as we go through it. Simple questions, yes, no answers. And if those results are interesting, well, then we will certainly circulate the results to you afterwards. For those of you who are not, who are on your phone in particular, you may not be able to answer it, but shout out loudly enough and hopefully we'll hear you and make note. And then finally, if time allows it, we will try to get to some Q&A at the end. So if you didn't manage to submit your questions in advance, please do put them into the chat function in front of you and we'll get to them at the end. So before we move on to the first of the questions dealing with damages, we might just bring up the first of our polls, which touches on the topic of damages. And the question there, which you'll see on your screen, do you understand how the RTB calculates the level of damages it may award? So if I can just ask you to please yes, no answers and submit your questions. We'll give 10 or 15 seconds for answers and then we should have the results on screen pretty quickly. Or maybe not that quickly, but they are coming. But thankfully, as somewhat expected, we have a phenomenal response there. 93% of people, Laura, don't understand how the RTB calculates the level of damages. So that kind of leads us in nicely to the first of our questions, which is, can you allow for disturbance, personal embarrassment, inconvenience, and stress as damages? Some adjudicators apparently seem to be somewhat wary of straying into the area of compensatory damages. So how do we actually go and define damages?
It's a good question and an interesting question, and it's not surprising for all that 93% of us don't feel that we understand the basis upon which the RTB assess damages. And there's a reason for that uncertainty, and it is that the Act actually says very little about damages. It tells us that the amount of damages that can be awarded is capped at €20,000, but precious little else. There is no statutory definition of the basis upon which damages can be assessed. And before I continue to answer the question, it's probably worth noting that the legislation didn't have to have been written like that. It could have set out very clear bases upon which damages should and shouldn't be awarded. It could even have gone so far as setting out particular tariffs that were payable in respect of particular wrongs. But it didn't do that. And in not doing that, it's left a gap. And that gap is filled by a broad discretion for the adjudicator and for the tribunal. That discretion isn't a completely untrammeled discretion. It's guided by common law principles. And the first of those principles is that the basis upon which damages are assessed should always be compensatory. The damages should seek to put the injured party, broadly speaking, in the situation that party would have been in, but for the breach or the wrong occurring. The basis of the damages should never be punitive. There is no role for an award of damages from the RTB, the purpose of which is to punish a party for having acted in a particular way. Now, I need to add a gloss to that, which is it would be wrong to take from that the idea that the way a wrong is committed never has any import or significance. If we take as an example a tenancy termination, the way a tenancy is terminated can of course be taken into consideration in an award of damages, but the focus would be to consider the way it was terminated because of the increased impact on the injured party, not from a point of view of punishing the person that has acted in the wrong way in terminating the tenancy. Moving on to the second part of that question, away from the basis and to whether particular types of loss can be recoverable in damages, and particularly non-pecuniary losses. So regularly people will come to the RTB and will seek damages for non-pecuniary loss, for embarrassment, stress, distress, inconvenience. And if you were to read the decisions of the tribunal on the RTB's website, you would be able to find instances where damages are awarded for those types of loss. More difficult question is, should damages be awarded for those types of loss? And here we're at the unfortunate scenario of having a question that has a very practical import. Are these monies properly payable in damages? But that has a very theoretical answer. And the theoretical answer is that there is a general rule that non-pecuniary losses should not be recovered in damages for breach of contract, except in certain exceptional categories where contracts have been regarded by the courts as being exceptional contracts in respect of which damages for non-pecuniary losses can be awarded. Insofar as I am aware, it has not been considered at the High Court or beyond in this jurisdiction whether contracts of residential tenancy are such exceptional contracts. It has been decided in England and Wales, and there it was decided that they don't form an exceptional class of contract. But I'm not so sure that decision would be followed were the issue to be litigated here. My own personal view is that it's unlikely that that decision would be followed. And I think it's likely that the High Court would take the view that damages here can be recovered for breach of residential tenancy contracts to compensate non-pecuniary losses. So I've said quite a bit there, but if we were to pull back to some key takeaways to avoid common pitfalls in the context of damages, if you are the applicant party and you're preparing to go to the RTB, work out the losses that you have suffered. Say, for example, you're a landlord and there are significant rent arrears. Many landlords would go to the RTB and say, well, this has been a significant cause of stress to me. But more than that, work out what actual pecuniary losses have been suffered. Has there been an overdraft charge, for example? And if you are the respondent party, if an award of damages has been made against you, I suppose the key takeaway is to interrogate that order very carefully. Is it clear exactly what the damages are that have been awarded, exactly the basis and exactly the method of calculation? And if you think that there is an issue there and it's worth it to you financially, you could consider an appeal, even an appeal from the High Court, an appeal to the High Court rather from the tribunal on a point of law.
Thanks, Laura. And I suppose in a nutshell there is irrespective of the heading and leaving rent arrears aside, the cap is 20k, is it?
The cap is 20k, yeah.
And that's payable, sorry, that's payable as between the parties. But is there a difference Is there a difference then between damages between the parties and sanctions?
There is a difference, yes. And if we just flick over to the next slide there. So just starting with those 2 points that you mentioned, that the cap is different. So sanctions are up to €15,000, and an amount payable in response to a sanction would be payable directly to the exchequer, whereas damages are paid directly to the injured party. I suppose another difference in sanctions to damages is that sanctions are part of this new remit that the RTB was given in July 2019 to investigate and impose sanctions in respect of certain types of improper conduct. So the conduct in respect of which sanctions can be imposed is much narrower than the scope of wrongs in respect of which damages can be awarded. And when you're thinking of improper conduct for sanctions, that's set out in the legislation, and sanctions can only be awarded in respect of certain landlord conduct, and it's landlord conduct in failing to register or update the register, landlord conduct in relation to rent pressure zones, failing to use the formula if the formula ought to have been applied, or seeking to rely on an exemption to the rent pressure zone formula that isn't open to you to rely on, and certain breaches in relation to notices of termination, giving a reason in the notice that's misleading, or failing to offer the tenant to come back to the dwelling following the expiry of the notice when that offer ought to have been made. And the final significant difference there on the slide between damages and sanctions is that sanctions are very focused on landlord conduct. So it's quite different to the compensatory focus of damages. So sanctions look at, did the landlord realize they were doing something wrong? If they did, how quickly did they desist? What explanation was given? So quite different damages and sanctions.
Thanks, Laura. I think, and following on then, Colm, Laura's mentioned notices there in various headings in which for service of notices. Notices themselves can be and are very varied and detailed. Is an error on the face of one of the notices fatal to the effect?
So you'll be glad to hear that there are some savers in the legislation which will assist a landlord where a notice of termination would otherwise be invalid. And I'll get to those in a moment, but maybe just before I do, to have sort of a quick helicopter view in terms of notices of termination and why there are so many issues around it, and where and why the pitfalls arise. So as Laura was saying a moment ago, in respect of damages, the legislation is relatively shy in detail. However, the same can't be said around notices of termination. And unfortunately, it's not a case of one notice fits all sizes. The actual notice that you serve is going to be dependent upon the ground upon which you're terminating the tenancy. And as a result of that, then there's various requirements for that particular type of notice. So I suppose the multiplicity of notices is one of the reasons why there's confusion around it. And also as well, because the law has changed from time to time, and sometimes you'll find that clients are using maybe old termination notices or old precedents that aren't up to date. So I suppose that's one very common pitfall. So I'd always just say, look, as a starting point, if Mason Hayes or if your agent aren't doing it, then you should go to the RTB website and make sure that you're starting from the right point. And I suppose the problem caused by invalid notices of termination can be, I suppose, a delay for landlords and costs incurred to landlords as well. So if you take a classic example, if a landlord serves a notice of termination on the ground of sale, for example, and a tenant has been in occupation for in excess of 8 years, so is entitled to the maximum notice. If once the notice expires and the tenant doesn't vacate the property, and the landlord then has to go to the RTB looking for vacant possession on foot of the expired notice of termination, the landlord really doesn't want the notice to be found to be invalid at that stage, because they'll have gone through almost a year at that stage in terms of the notice period and actually bringing the dispute and getting to the RTB to have a finding against them. And as you'll appreciate, that'll put them back at the start again, where they'll have to go through the entire process. Or if you take another common example where you have a tenant who's in arrears of rent and a landlord has terminated on foot of the arrears of rent, and again, the tenant hasn't vacated and or paid the money, and the landlord then has to go to the RTB to bring a dispute looking for vacant possession and the arrears. You again don't want to find that actually your notice of termination is invalid, because you're going to be out of pocket and going to go back to the start of the process. And invariably, that type of tenant isn't going to be paying rent during this extended period, so your losses are increased. So I suppose just the pitfall is just make sure that you're always working from the right legislation, the current legislation, and the right templates. But look, things happen, and invariably there are going to be issues, or issues are going to arise from time to time. And as I said, there are some saving provisions in the legislation that will hopefully assist you there. So the first is the slip rule, and that was introduced in 2016. And effectively, it allows an adjudicator or the tribunal to effectively gloss over what is, for all the world, sort of a minor or small error on the face or the way in which the notice of termination was served. So classic examples there are examples that the tenant's name has been incorrectly spelt, or that the property address has been incorrectly spelt on the notice of termination. But the key decider there is that regardless of the slip or the error, there's no prejudice suffered to the party in question. And provided there is none, then the RTB should apply the slip rule and not find the notice to be invalid for that particular reason. And I suppose that only really gets you so far in terms of these sort of more administrative or clerical errors. But what about the more egregious errors? If, for example, you've calculated the notice period incorrectly and you fall 5 or 6 days short of what the tenant should have gotten, are you then going to be faced with having to go back to the start of the procedure? And up until last summer, that was the case. And last summer, when the revised legislation came in, it introduced this concept of a remedial notice, which is a helpful introduction into this particular area. And effectively, it'll allow a landlord to cure a breach that is more significant than something that is purely administrative or clerical. Now, there is a slight drawback to it in that a remedial notice can only be issued if the RTB has found, either at the adjudication or at the tribunal, that the notice is valid in all other respects, save for this one particular defect, and that it can be cured by this remedial notice. So you do have to serve the notice, go through the period, go through the dispute, and then have this finding. And effectively, you're given leave to serve a remedial notice to cure the defect. So say, for example, in that example where I said that you might be 5 days short, if you've gone through the process and you're given leave to serve a remedial notice, that remedial notice would be 28 days plus the 5 days that you've been short. Or if the defect is something other than, say, a notice period, you may have excluded, for example, the statutory declaration that has to be accompanied with some notices of termination, you may be allowed to reissue a remedial notice with the accompanying statutory declaration to get you back to where you should have been. So there are two helpful provisions in the legislation that, as I said, were introduced in 2016 and 2019 respectively. But practically speaking, the remedial notice does require you to go through the dispute process. And if, for example, you're carrying out a file review just in the ordinary course and you actually happened across a notice of termination that you'd served, and it became very obvious to you that the notice was clearly invalid, you may actually take the decision to pull that notice, to formally withdraw it from the tenant, and to reissue a corrective notice that is on all fours with the legislation. And obviously, while you're going to have to give the correct notice period, again, you may find that in the overall scheme, you're saving yourself some time. So there are plenty of opportunities for pitfalls when it comes to notices of termination. So I'd say take your time and check again.
Thanks, Colin. Laura, moving on to the actual lifeblood of residential tenancies, the idea of rent.
Yeah.
Couple of questions on rent, and it's focusing on two of them. In circumstances where a valid notice of termination has been served by a landlord and a tenant is overholding, do you think is the landlord prejudicing itself by continuing to accept rent from that tenant?
No, I don't think so. And I think a landlord can continue to accept the rent. I understand the concern, and I think probably in commercial tenancies, we'd take a slightly different view of this, and we'd be very concerned about the acceptance of rent following the expiry of a notice of termination. And if rent was accepted, we'd be clear to be labelling it as something other than rent. But I don't think those issues arise at all in the context of residential tenancies. I've read a great number of decisions of adjudicators and of the tribunal, and I have never read a decision where a notice of termination was held to have been impliedly rescinded by the receipt of rent following expiry. So I don't think you need worry about it. If you wanted to, as a landlord, out of an abundance of caution, you could write to your tenant and say, look, your notice is expired, you're still there, I'm continuing to accept this money, but I'm doing that without prejudice to the fact that your tenancy has terminated. But I don't think there's any need to be sending out letters like that.
Okay, thank you. And we often hear, be it hear or read about the RTB's rent index to play in establishing the market rent for a property.
Yeah, so there are a number of types of evidence that parties rely on when they're establishing the market rent at an adjudication or before the tribunal. The rent index is one. Advertisements is another. The rent actually received in particular dwellings is a third. And there is no stipulated hierarchy anywhere that any one of those reasons would take precedence over the other. In terms of what is the role of the rent index, if you were to read the decisions of the tribunal, you would see different decisions give a different import to the rent index. And I don't think that's an example of the tribunal acting in a way that's inconsistent. Rather, I think it just responds accurately to the fact that the rent index is differently useful in different scenarios. So, for example, the rent index takes an average rent over an area. So there'll be particular places in Dublin where the rent is very much higher than the average rent. And so the rent index wouldn't be a useful source of evidence of the market rent there. However, you might have another scenario where there are few advertisements or a concern that the advertised rent wasn't the actual rent being paid. In that scenario, the rent index gives you a record of actual rents paid, and so the rent index might be a very useful piece of evidence indeed.
So it's useful, but not definitive.
Not definitive, but useful. That's right. And I suppose that again would be a pitfall for tenants. You know, you would come across tenants that arrive for an adjudication and think that it'll be a slam dunk, that the rent needs to be in the amount of the rent index, and that isn't the case.
Okay, thanks, Laura. So, and Colin, then again, linked to rents, it's like we have a theme here. And the idea of high rents and RPZs, if rents, depending on how the current economic cycle pans out, if rents start to fall, do you see this having any impact on RPZs? And if so, what kind of impacts do you see it having? I know we're asking you to look into the future there a little bit.
So I think, as I said, we're probably going to have to wait quite a while to see how this actually pans out. There is obviously talk around town that rents are reducing, but if you actually look at the figures that were released from the RTB in April in respect of Q4 for 2019, it looked like the average rents were slightly down over the last number of years in any event. So just going through rent pressure zones, and then I will come to that particular question, Jamie. Just by way of overview, I suppose we all know that an RPZ is a designated area within which the rent can't be increased by the 4%. And in the context of your question, it's, I suppose, important to bear in mind what the purpose of the RPZs was, to make sure that there was some sort of certainty around the levels of rent, and also to make sure that the market wasn't overheating. And in terms of how RPZs are designated, there was 5 designated originally back in 2016 when this was introduced. And that has grown year on year with the exception of 2018, with the most recent RPZ designations having happened in April of this year. So there is definitely RPZs on, I suppose, continue to grow around the country. And in some circles, there is almost a concern or a feeling that it's almost a question that the entire country is going to be an RPZ at one stage or another. And how an RPZ is actually designated as such is quite prescriptive in the legislation. So there's a process to be followed in terms of a proposal is made by the Housing Authority to the Minister. The Minister then makes a request of the RTB to carry out a report. And in carrying out that report, the RTB will have regard to the average rents in the area over the last number of quarters. And if a certain percentage growth has exceeded in the last number of months. And provided those criteria are satisfied, then the Minister will make an order designating an area to be an RPZ. And an RPZ can only be designated at the moment for up to 3 years. And all current RPZs are fixed until 2021. However, there is provision for an RPZs to be what I'm calling, I suppose, delisted, for want of a better word. And in doing that, regard would be had, again, to the various steps that I've just discussed and the level of rents that are actually being collected around the country. But because of the test that has to be applied over the last number of quarters, I don't think we're going to see a delisting of RPZs in the short term. And just in terms of, I suppose, pitfalls in this particular area, again, the calculating of rents in RPZs and rent reviews generally, again, is quite prescriptive with detailed notices required. And the longer the notice, in my experience, the more opportunity there is to get something wrong. So just to make sure is to obviously check where the dwelling is. And again, this is important because the introduction of RPZs on a phased basis, you need to make sure that even though something isn't in an RPZ today, if there has been a change in the law, it could be an RPZ by the time you're doing your rent review. You also need to understand when the actual area was designated an RPZ and when was the last rent review. I suppose just another thing or another attached point to this, Jamie, is that even if an area was delisted, as we're saying, from an RPZ, the underlying rent review rules are still going to apply. You're still going to have to set your rent by reference to market rent. So that's always going to be your starting point.
Thanks, Colin. Laura, moving on to certainly, in my experience, one of the most contentious areas is the area of deposits. I know back in 2015 in the Residential Tenancies Amendment Act, there was a proposal which hasn't been enacted for a deposit protection scheme, whereby the RTB would hold and manage all deposits in all residential tenancies. And maybe just, sorry, Laura, before I come to you, we might just pull up another poll here to see what people think. So that legislation isn't law yet, but do people here on the webinar think that it should be brought into law such that the RTB should manage and hold the deposits? And we'll just give 10 or 15 seconds there, please, to vote on that. And we should see the answers shortly. Fairly even split, but the no's have it at 56%, Laura. I suppose that kind of leads to, certainly, I'm sure all of the no's are those who submitted these questions, but we'll prove them now anyway. First question is that does the landlord need to give the tenant the opportunity to cure or remedy any defects in a dwelling before paying the deposit?
No, I say that the landlord doesn't need to do that. There's certainly no legislative provision that would require the landlord to do that. And there's very good practical reasons not to do that. You know, we're thinking of the deposits, the tenancy is ended, the tenant has no right to access the premises. That would need to be facilitated. It would lead to delays. No need to give a time following the end of the tenancy to remedy damage. It's just worth pointing out there, though, that a common pitfall would be, whilst a tenancy is ongoing, for a landlord to say that there is a defect the tenant has caused to the dwelling and jump the gun in making an application to the RTB for dispute resolution to require the tenant to put that right. Absolutely, whilst the tenancy is ongoing, the tenant needs to be afforded quite a bit of latitude in relation to timing for repairs and so on. But no need to give an opportunity to remedy before withholding the deposit.
I think you kind of touched on it there, but a double barrel question, Laura. So, like, how long do you have to wait, or how long can you wait before returning it? And what are the consequences of a landlord wrongly withholding all or portion of that?
So in response to the first part, promptly is the word used in the legislation, not that precise, allows the surrounding circumstances to be taken into account. At the moment, when there might be a justifiable delay in an inspection, what's prompt might be longer than what would be prompt at another time. A couple of weeks probably, depends upon the reasons for which the damages, the deposit rather, is being withheld. And then in response to the second part of that question, what are the consequences? Well, if the deposit is withheld wrongfully, in whole or in part, or indeed if the deposit is returned, but returned late in breach of the obligation to return the deposit promptly, then damages payable by the landlord to the tenant. Those damages would be assessed on the principles we've already talked about, and the focus of those damages would be to compensate the tenant for the damage that the tenant has suffered, not to slap the landlord on the wrist for the fact the deposit was retained.
In terms, Laura, of slapping the landlord on the wrist, if a landlord gets it wrong, messes up on the deposit, can it be sanctioned? We touched on sanctions earlier on.
Deposit retention isn't improper conduct for the purposes of the sanctions. Okay,
thanks. And then no doubt this is submitted by a landlord, Laura. The last question then, if an RTB dispute arises out of the deposit retention, what practical steps can a landlord take to increase their chance of success in defending the claim?
Yeah, so the landlord really needs to be aware in the first instance of the reasons according to which a deposit can be withheld. So it can be withheld for rent arrears, or it can be withheld because there is damage to the condition the dwelling was in at the commencement of the tenancy, and that damage goes beyond that which is attributable to ordinary fair wear and tear. So the landlord needs to have reasons with an amount specified next to those reasons that the landlord has chosen to deduct from the deposit. A common pitfall in this context would be to rely upon a provision in a lease which says, for example, that a specified sum can be withheld from a deposit in respect of something like cleaning. Lots of leases have those provisions, but actually you cannot contract out of the landlord's obligation to return the deposit unless you're agreeing something that's more favourable to the tenant. So I've never read a lease that contained this provision, but if a lease said under whatever prevailing circumstances, the deposit must be returned to the tenant at the end of the tenancy, that would be a good binding provision and the deposit would have to go back to the tenant. But provisions that are less favourable to the tenant, like a provision that said, you know, an automatic fixed deduction will be made for cleaning, that provision would not hold good. And very often landlords deduct those sums because it says they can in their lease, and then they trip up over that in the RTB. So it's always by reference to the provisions that are in the Act. And another slip up is it's widely accepted that a landlord can't recover amounts from a deposit to get that dwelling ready to be let out again. And a way that a landlord can protect themselves in that regard is to, before withholding the deposit, think about that. Think about the amount that would normally be spent on cleaning or on redecoration works before the dwelling was let out again, and see how the particular scenario is different or greater than that, and use that as the basis to withhold the deposit, and then have that information at the landlord's fingertips to give to the RTB adjudicator. And if the landlord can show that they've carried out these sums and done this working out, gives far less scope to the adjudicator or the tribunal to come up with a different figure and decide something was retained that ought not to have been.
Okay, thanks, Laura. So we've touched there on misbehaving landlords. And I suppose we might just have another quick poll on antisocial behaviour in tenants, just to distract us all from the alarming amount of Q&A that's coming in there at the moment and that we might get to. So you'll see the question there in front of you. Do you think it would be of use to have some form of tenant rating system to assist landlords in taking on new tenants? So if you wouldn't mind just taking a few seconds just to answer that, and we'll get the results shortly on screen. So, an overwhelming yes there, Colm. Which is good to see. I suppose it probably leads into a number of the questions that we've received on this. And I suppose looking at antisocial behaviour, first thing to look at in the context of antisocial behaviour, in terms of the types of warning letter that need to be served in respect of antisocial behaviour, when can you proceed directly with a 7-day termination notice?
This is, I suppose, one of the common, pitfalls or mistakes that we often see around antisocial behaviour. And the first thing, just before you even get to the warning notices and the termination notices, is to understand that there's effectively different degrees of antisocial behaviour, for want of a better explanation. So I've set them out there on the screen. The first is behaviour that constitutes an offence. So that's the most egregious type of antisocial behaviour, as you can imagine. And classic examples of that, for example, are drug dealing or drug taking on the premises, or sometimes prostitution, even we've seen that as well. The second class there is behaviour causing fear, danger, injury, damage or loss. So again, that's egregious, but maybe of a less severe degree to category A. The final one then is persistent interference with peaceful enjoyment. And that's in respect of others in the property or in the building, or maybe sort of in the very general local area. And the reason you need to understand the degrees of antisocial behaviour is because the warning notice and termination notice differ depending on which degree or which category you fall into. So if you're in category A or category B, no warning notice is actually required at all, and you can move straight away to issue your 7-day termination notice. However, if you're in category C, so persistent interference, an example of that would be parties would say every weekend over the course of a number of months, for example, 1 or 2 instances of noise will not necessarily get you there. And in that case, you need to issue your warning notice, giving the tenant a reasonable period to cure the breach. Failing which you can then issue your 28-day termination notice. So as I said, practically speaking, what we see is that you sometimes have landlords who are issuing 7-day notices, but actually it's only a really category C antisocial behaviour, and they haven't taken the preliminary step of issuing the warning notice. And one of the other common pitfalls or problems that we see around antisocial behaviour is the evidential piece when it actually comes to having the dispute heard. So typically what you'll find is that actually the antisocial behaviour isn't of any real concern to the actual landlord itself, and it's brought to their attention rather by a neighbour of the property or maybe by somebody else who's living in the building or the local area. And they may be very happy to hound the landlord with telephone calls and short emails citing instances of antisocial behaviour, all of which the landlord will use to ground their application for dispute resolution before the RTB. But then you may find that actually it's only the landlord's agent or the landlord themselves that appears at the hearing without the actual support or evidence of those who had complained originally. And that evidential deficit is really going to cause the landlords problems in bringing home a claim for antisocial behaviour. So you really need to make sure that you have it documented, and then the best evidence is to have those who are complaining of the issues there with you on the day to bring home your claim.
Am I right, Colm, in thinking that now is the climate to have my offensive, persistent and dangerous eyes wide shut style parties? Like in the current COVID-19 crisis, antisocial behaviour is out the window.
I'm unhappy to say it, but yes, you can have a wild party at the moment because under the COVID legislation, which we discussed on our webinar a number of weeks ago, no notice of termination on any ground can be served during this emergency period. So the emergency period started on 27th of March and we're now effectively halfway through it. It's due to end at the end of next month under the current regime. But it does leave the landlord in an unsavoury position that they can't do very much other than issue warning notices at the moment. So if you are a landlord and you're experiencing antisocial behaviour, and I would say on the more extreme end of the spectrum in terms of A and B, what the RTB are suggesting is that you would contact the local Gardaí and ask for their assistance. I think this is a practical solution, and also even if it doesn't resolve the matter, you can use that as part of your evidence when you come to actually issue your termination notice down the line. And there is another, I suppose, final sort of nuclear option, for want of a better word, in that you can request the RTB to take some steps in relation to it in the form of issuing injunctive proceedings against the offending tenant. Again, I think that's going to have to be the most egregious type of antisocial behaviour, extreme offences, before the RTB would roll in and get behind you on that one.
Thanks, Colm. And I think that kind of brings us full circle then to our, having touched on COVID-19. I might just perhaps to wrap it up then ask you both to take us through some of the implications, some of the broader implications, and set out where we are and where we might be going with COVID-19 and residential tenancies. Laura, I might just ask you to take us through the first couple of points.
So at the moment we're in the emergency period being 3 months from the 27th of March. That period might well be extended, possibly seems reasonably unlikely at the moment, but who knows. And as Colm said, we did a webinar a couple of weeks ago on the impacts of the legislation during the emergency period that refer to rent and tenancy terminations. So in relation to rent cannot be increased during the emergency period. You may, however, still serve your notice of rent increase. And actually, because market rent is assessed at the time you serve your notice, if you can serve a notice of rent increase, and if it seems likely that market's rents will drop, it might be a very good idea to serve your notice of rent increase now during the emergency period, even though that increased rent will only take effect at the end of the notice period in your notice, and of course at the end of the emergency period. Tenants, though, have to carry on paying their rent. There's no rule that says they don't. Landlords and tenants can, of course, reach their own independent consensual agreements around the payment of rent if they so wish. And a point I've noted there on the slide is rent for new tenancies. Since we gave our last webinar, the RTB have issued guidance, and it's clear from that guidance that the RTB say that if you're setting the rent for the first time in a new tenancy in an RPZ during the emergency period, that whilst you can set that rent in accordance with the formula, you can only charge the passing rent, so the rent that had been previously payable for tenancy of that dwelling. You can only receive that lower rent up until the end of the emergency period. And then once the emergency period ends, the higher rent that is set out in your lease will kick in and take effect. I think, Colm, now you're going to talk about termination.
Yeah, so under the COVID-19 Act, the general rule is that a landlord cannot evict a tenant. So as I said, that's the general rule, but there are some exceptions to that. So if a landlord has an RTB determination order or a tribunal order that requires a tenant to vacate, then the tenant should do so. But I suppose if the tenant fails to do so, the next step then is actually looking to enforce that through the courts. The courts are, I suppose, largely closed at the moment and only kind of getting back on their feet at the moment. And you may be faced with quite a delay in actually enforcing that RTB order that you have. But as I said, the general rule is there that you can't effectively evict someone during the emergency period. And as I noted when I was speaking about the antisocial behaviour, at the moment, no notice of termination can be served on any grounds, but you can serve the precursor to the notice of termination in the form of a warning letter. And I suppose the health warning that comes with that just to make sure if you are using any templates that it does not say at the bottom that immediately on the expiration of the warning letter and provided the breach is incurred that you're going to serve a termination notice, because you obviously can't do that at the moment. And then practically speaking, where are we at with the RTB? So I have a number of cases, for example, in the RTB that were scheduled to take place in early March and early April. They have all been adjourned generally at the moment, and new dates are not being assigned. And what is actually mooted at the moment by the RTB is that they may move to, or look to move to, a paper-based adjudication. So in the first instance, the RTB is asking that parties who are signed up for adjudication might consider, in the alternative, taking part in a telephone mediation. In my experience, that's not the most practical of solutions, but it is an option for landlords if they're looking to advance matters. This alternative paper-based adjudication is what I think may have some difficulties, particularly if you have a professional landlord on one side and maybe a non-so-professional tenant on the other side, who is going to be making paper-based submissions to the adjudicator. I think it's going to result in a number of questions that in the ordinary course would just be answered in the adjudication over and back, and obviously you don't have that on the paper-based system, so I think it could result in rounds of correspondence. And then finally, just virtual hearings is the last bullet point there on the slide. So the RTB is looking at carrying out virtual hearings, so the adjudication will be carried out just like we're having now, for example, maybe on Zoom, and the RTB are looking into the legal issues and the logistical issues around that. But it would, I think, be a positive, regardless of COVID-19, I think be a positive development and might assist in advancing matters and make life a bit easier and having matters adjudicated and concluded before the RTB.
Well, Laura, thanks very much for that. There's an awful lot there to have brought us through in just over 40 minutes, so thank you very much for that. As I warned you, there were questions coming in thick and fast, and we will try to get to as many of those as we can in the time we have available. I think the first question here, Colin, might be for yourself. Are rent decreases allowed during COVID-19? And if so, what steps might be taken?
So rent decreases are absolutely allowed during COVID-19. Now, whether or not a landlord is minded to actually give a rent decrease is another thing, and there's no obligation on the landlord to do so. I think there's a number of practical steps. Look, if a landlord is minded to help a tenant out during this period, I think they can reach agreement, and then it should be clearly documented. And you need to make absolutely certain that there's no ambiguity in terms of what is agreed. So are you agreeing that the rent is going to be reduced indefinitely? Are you agreeing that there's going to be a rent reduction for a defined period after which the rent will revert? And I think it's important at the end of that document as well, be a letter or a formal agreement, that you make it very clear that what you are doing in that document is not a formal rent review for the rent review mechanism, because what you don't want to do is set a new floor for your rent when you come to your rent review in 12 or 24 months time. So you should be expressed in relation to that.
Okay, thanks. If a notice of termination was issued prior to the emergency period, does it now need to be extended by 3 months?
Do you want me to take that, or?
Do you want to take that, Colin?
Yeah, so what the COVID-19 Act does, it effectively pauses notices of termination that were served prior to the emergency period and that are due to expire during the emergency period. So if you went in, if on 27 March, when the emergency legislation was introduced, there was, let's say, 30 days left to run on the notice of termination. Once the emergency period expires, which at the moment is the 27th of June, there will still be 30 days to run on it. So the notice period is, as I was saying, paused during the emergency period.
Okay. Can a remedial notice be disputed itself to the RTB? Which of you want to take that?
I'm happy.
Laura?
I don't see any reason why there wouldn't be an ability to refer a remedial notice to the RTB. The purpose of the remedial notice is to cure the defect. And if your curing document continues to contain a defect, I think that there would only be permissible that a tenant, for example, would be entitled to challenge that. The purpose of the remedial notice isn't to give a landlord a carte blanche to get things wrong indefinitely to the detriment of the tenant. So in those circumstances, I think there has to be an ability to challenge a remedial notice.
Laura, just you can see a feeling left out there. You might. Does a landlord who's drafting a notice of termination always need to give the tenant the opportunity to reoccupy?
No. So if you're terminating a tenancy that is not a Part 4 tenancy, the classic example of that would be student accommodation, or a building divided into two premises, one of which the landlord resides in and the other of which the tenant resides in. Those tenancy terminations that are not Part 4 tenancy terminations never need to include an offer to reoccupy. If you are terminating a Part 4 tenancy, and if you are terminating that tenancy because of a breach by the tenant, or because the accommodation has become unsuitable to the tenant's needs, you do not need to give an offer to reoccupy. But if you're terminating a Part 4 tenancy for any of the other reasons, sale, change of use, development, substantial refurbishment, yes, then you must always give an offer to reoccupy.
Okay, thanks. And then Laura, you might take this one too, if you don't mind. Can a renter be served during the emergency period if the increase itself doesn't take effect until after the lifting of the restrictions?
Absolutely, yes. And I think that is probably a very good idea. If according to your normal schedule of rent reviews, you're allowed to serve a notice now of rent review, I think that's a good idea.
Probably a good idea here, I think, Laura, just touching back on the prompt return of deposits. And I haven't seen it myself, but if the actual was defined in the lease itself, would that take precedence over the act? So if the lease said it will be returned within 2 weeks, and the landlord didn't do it, but nonetheless did it within 3 or 4 weeks, could the RTB deem that to be prompt and take precedence over the?
Yeah, I think probably yes, because it would be more favourable to the tenant than the alternative. So yes, I think it would take precedence, and it would need to be returned within that time. Conversely, if it had said the landlord, can wait 6 months, I mean, that's a silly provision. We wouldn't expect in a lease, that wouldn't hold good. But yeah, if there's a very narrow time frame, I think that's in favour of the tenant and would hold good. Okay.
I suppose to show that we're not fully landlord friendly, we also have a lot of people representing tenants on the webinar as well, Laura, and they've also suggested that we might have a ratings system for landlords as well. So we have time for a poll on that one, but point noted. Yeah. But Laura, to go back to your point where you don't agree with the RTB, new tenancies in the setting of rent, could you run through that again? Let's have 2 or 3 questions on that.
Yeah, absolutely. So if you have in a rent pressure zone, a new tenancy, you are setting that rent by reference to the rent that was previously charged. And if you're allowed increase by reference to the time that's elapsed since you last sent the rent will increase, and you'll set your rent at that new increased level. Now, what the RTB have said in their guidance is that at the moment, yes, in a rent pressure zone, set the rent in your lease at the amount that you would normally set it, forgetting the fact that we're in the emergency period. But until the emergency period ends, the only amount that you should be able to recover from the tenant is the rent that was previously payable. So the passing rent under the previous lease before it was increased. Now, we internally don't necessarily think that's a correct interpretation of the legislation, because the legislation refers to an increase in the rent of the tenancy, and it's hard to see how the setting of the rent in a new tenancy should be caught by that. But that is what the RTB have said in their guidance.
Okay, thanks, Laura. And I think just as we're coming up on time, we have time for one more question, and I am conscious that we haven't got to everyone's questions. But Laura, is there anything in the COVID-19 rules and regulations that will allow a residential tenant to in fact unilaterally vacate and surrender their lease because they're now working from home and returning to their family home, which is not in Dublin?
I'm happy to answer that if you like.
Yes, no, thanks, Laura.
There's nothing that gives that right.
Okay, perfect. Thank you very much, Colm. Thanks, Laura, and thanks to all of you who attended and submitted questions. We will look at all the questions that we haven't got to and try to come back to you. For anybody who's actually provided their names or contact details, we come back to you by email, or please do pick up directly with either myself, Colm, or Laura. But in the meantime, thanks very much, everybody, and have a good afternoon.
Thank you.
Thanks.